Namaskar and welcome to Sansad Television. I am Vishal Dahiya and you're watching our show Perspective, where we bring you detailed analysis of key national and international issues. Today we're going to talk about the death penalty debate. The Supreme Court has ruled that all courts must consider pre- and post-crime conduct of a convict to ascertain mitigating grounds to avoid imposition of the capital punishment. Now, the apex court's Friday verdict puts onus on the judiciary to look for a convict's reformative qualities. This further limits the possibility of imposition of death penalty, which in 1980s got restricted to only rarest of rare cases. The Law Commission of India in 2015 had also recommended that the death penalty be abolished for all crimes other than terrorism-related offences and waging war against the country. Over the past several years, concerns have been raised that the death penalty has been awarded mainly considering only the crime factor while overlooking the accused. In today's episode of Perspective, we will analyze and understand all aspects of this issue. And for more on this, we're joined by a distinguished panel of experts. Let me first introduce them to you. Beginning with, we have with us in the studio Senior Advocate Sanjay Chadha, who is joining us. Welcome, Mr. Chadha.
Thank you.
We're also joined by Mr. Suresh Chandra, former Law Secretary with the Government of India, and Mr. Ashok Bagaria, the legal editor of TV9, is also with us. Welcome, both of you gentlemen, as well. Let me first begin with you, Advocate Chadha, and let's start by understanding the context of the Supreme Court's latest ruling on this issue as well. Let's try and understand what Supreme Court has said and why it has said so.
Well, the most important thing, as you said, in 80s, we had got the gist of those judgments was that only in rarest of the rare cases, rarest of the rare circumstances, when such an heinous crime has happened, then only we should, look for a penalty like death penalty. So it's remote. It's very rare that it will be given. Now, I would say another caveat is added with this judgment, which you just mentioned, wherein the Supreme Court has very specifically said that during the trial, because as we all are aware, the trial takes a quite lengthy time, and not only that, after that you go for an appeal if there is a case where death penalty is there. So on an average, it takes 7 to 10 years time. Why I'm saying 7 to 10 years, I can give an example of Nirbhaya case, which took 7 years. Despite being lensed by all media houses and everybody. Every day it was covered in almost all the newspapers. So here, what important thing which, the takeaway, as I can say, from the Supreme Court is that the conduct during those 7-8 years, which the person who is going to be convicted has shown, what kind of activities he has done, should also be taken into consideration. That's what is the gist and a very important factor. I think this further restricts the awarding of death penalty. But we have to always keep in mind that death penalty, as per the rule, would be given to only and only in the cases where it is the rarest of the rare case. In extreme circumstances, a death penalty should be awarded.
Okay. Let me bring in Ashok here. Ashok, the Supreme Court has been working on it for years in terms of, forming the guidelines for the mitigating circumstances, as we have seen. Now, if you have to look at this journey from 1980s onwards, when this entire scenario vis-a-vis the death penalty was restricted to rarest of rare cases, to 2022 now, if you could take us through, what all has transpired in terms of the high points of this journey on the issue of death penalty, and where do we stand now?
Well, Vishal, in the last 4 decades or so, as far as the application of death penalty is concerned, it's been very erratic. In the sense, the trial courts have been very erratic in awarding death penalties to convicts, because what we have seen is that most of the cases in which death penalties are awarded by the trial courts are either set aside, not confirmed by the high courts, or when they come to the Supreme Court, in the final appeal, they are set aside and the death penalty is reduced to either a life term or 20 years or 10 years in jail. So what has really happened in the last few years is that there has been a concern which has been expressed in the legal circles that the trial courts have been very, very liberal in awarding death penalty and actually giving push to the idea of retributive justice. So, what the Supreme Court has over the years felt is that although we have a base which has been laid down in the Bachchan Singh case that death penalty should be given in very exceptional circumstances. Life sentence is a rule and death penalty is an exception. They also laid down the rarest of the rare test. And what has really happened is that the misapplication of the rarest and the rare test. So, in the Bachchan Singh case, what the Supreme Court said was that when any particular court is handing out the death penalty sentence, it has to balance the mitigating and aggravating circumstances. And once they are balanced out, you have to see which of the scale is heavier, and on that basis, you have to award the death penalty. But of late, what's happening is that we have seen that there have been many instances that the trial courts have heard arguments on sentencing, and within hours of the conclusion of the arguments, they pronounce their verdict. And there is no proper weighing of the aggravating and mitigating circumstances. So, what has really happened in the last 40 years is the misapplication or the abuse of the Supreme Court guidelines which have been laid down in Bachchan Singh case. Now, what the Supreme Court wants is to set the record straight and say that, look, all of this has to stop. And what is really important, Vishal, I want to say is that as on 31st December 2021, there are around 488 people who are on the death row. In the year 2021 itself, there were 144 instances in which death penalty was given out by the trial courts. So what we are witnessing, this has become more of a trend that the trial courts have actually hurried through, or rather not properly applied the law which is laid down in the Bachchan Singh case. And this is resulting in the number of death rows in our prisons piling up. The number of convicts who are on death row is piling up.
Okay. Mr. Suresh Chandra, let's also understand this from the perspective of executive and the legislative as well, because making the law is in the domain of the parliament, and the law is already there. It exists. It's about the interpretations and, of course, the way judiciary is now putting in place mitigating circumstances as well. And that 4-decade-long journey which Ashok just described about, and several checks and balances being put in place. How has the government and the executive looked at it all through these years, and where does it stand now?
This debate, whether the capital punishment should be there or it should be abolished, has been for a very long time. And the Supreme Court, after a number of cases, as our colleague have already mentioned, right from Bachchan Singh and all those cases wherein the death penalty has been awarded, the Supreme Court had very categorically and clearly brought out the principle of rarest of the rare cases. And this is the latest judgment, to my mind, is also to arrive at the rare of the rarest category. But on the government and also the international pressure was always there that it should be abolished. Whenever we used to go for any, bilateral agreement or multilateral agreement on the international platform, then there used to be, pressure, or they were not agreeing some of our provisions because we had the provision for capital punishment. But why capital punishment? We have to go into this aspect because there are three theories. One is the preventive, retributive theory, and the reformative. Retributed nowadays have come down. They are not just to punish somebody because he has done this. More thrust is nowadays is on the preventive, as well as these are the theories which are more acceptable. That is the reformative. And of course, there are certain circumstances, as in the judgment I could not go through completely, but I was going through the UU Lalit, Justice UU Lalit, who has been, expert on the criminal justice, he had been very beautifully, while balancing, had brought out those mitigating factors and the guidelines for the judiciary, and as well as what should be the relevant material, relevant information which should be taken into consideration.
Okay.
So I think this is something, thesis, antithesis, and synthesis. So long as the law is there, so long as the law is not struck down or law, is not amended, I will say whatever you say, either the rarest of the rare cases or the categories like terrorist or elements or some certain other persons who are waging war against the government, or maybe certain other very serious offenses against the humanity or the large number of persons, like which has been mentioned.
Okay.
So I am of the view that the government always goes by, by the public opinion, as well as the requirement of the national and international, opinion.
Okay.
And I have seen while we were undertaking this law commission's report. At that time also it was discussed and at various forums, and finally it was decided that we should not abolish it, because the balancing is being done by the Supreme Court,
Okay,
or by the judiciary.
okay,
And the government, when they are prosecuting and seeking capital punishment, at that time they are trying to bring it in the rarest of the rare cases,
okay,
for the sake of independence of judiciary, and for the sake of this, that the administration of justice will be done in a reasonable manner.
okay.
This has been kept. I don't know, maybe in future time, when we become either more civilized or we succumb to the international pressure, the parliament may decide that let us.
Okay. Now that mitigating circumstances have been put in place, that also brings in focus one more aspect here. And Sanjay ji, I'd like to bring you in here. Is that this also, if you look at Supreme Court's earlier, stand on this particular issue, it clearly said that the court should respond to society's cry for, justice being delivered in heinous crimes with commensurate punishment.
Exactly. That is very, very important. What, at the time when you are giving proper importance to mitigating circumstances, as stated by Justice Lalit, who himself, as Suresh ji has also mentioned, that was a dynamic lawyer of as far as the criminal law is concerned, and now he's delivering very wonderful judgments. So this, very correctly you have stated that yes, that aspect is to be taken into consideration, but what about the victim's side? What happened to those persons who have suffered? Whether, by the act of this is where you have to do, weigh both the things and then decide what is to be the next course of action.
Okay.
What will happen to the pain, agony, the disturbance, which not only the victim, the entire family, the entire kunba of that particular family will be facing when they see that this heinous crime has happened, and which properly falls in, I'm just saying basis on, you just look into the facts of the circumstances. That is very, very important. And that's how rarest of the rare cases, first you have to see that.
Okay. But mitigating circumstances is one aspect which we are debating here, something which, the Supreme Court has clearly laid down the guidelines for. Ashok, if you look at that aspect, as Sanjay ji is referring to, and what I was pointing out in terms of what Supreme Court had earlier said, the question here is that the mitigating circumstances also talk about pre and post conduct of the convict after the crime has been committed. Correct. Now, one opposing view is that why consider the post conduct, the conduct post the commitment of crime?
Well, Vishal, I agree with what's been said, but you have to understand that the courts can't become bloodthirsty and start handing out death penalties in every case where death penalty is prescribed. So, what the Supreme Court has done, very objectively, it's laid out a test. It said the test is rarest of the rare tests. The second thing, they have said that life sentence is the rule and death penalty is an exception. So keeping these two principles in mind, you have to weigh things objectively. Now, as far as mitigating why, now the question arises is that what about the rights of the victim? Now, you see, as far as the criminal jurisprudence is concerned globally, it has evolved. The concept of criminal jurisprudence and punishment has evolved from the retributive punishment to deterrent punishment to reformative punishments. In fact, yesterday itself in the Yasin Malik case, what we saw was that the NIA, which was probing a terror funding case, needed the court to look into give Yasin Malik the death penalty. However, the court rightly applied the principles which were laid down in Bachchan Singh and Machi Singh's case, and it balanced the mitigating and aggravating circumstances. But now, most importantly, what you have to see is that why is mitigating circumstances more important? And before I answer the question why, we need to look what are the mitigating circumstances. So if we look at what the court is saying, is that the court says that a mitigating circumstance is the age of the convict, what is his family background, what was his early family background, what is his educational status, what is his income, what are the chances that this person who's being held as a convict or who's being convicted of an heinous offense, what are the chances that he can be reformed? Okay. So you see, these are the mitigating circumstances. Now, coming to the question why mitigating circumstances need to be taken into account, is that the courts, the whole jurisprudence is shifted, as I pointed out earlier, from the point of retributive justice to reformative and deterrence justice. Now, the whole idea of keeping this in mind or keeping a person in jail is to make sure that this person who's become a menace to the society does not come back into the society and repeat the same offense for which he's been charged. Mm-hmm. So what the courts are trying to do is trying to see that we are not bloodthirsty. We do not prescribe to the idea of death penalty to be given in every case. For us, for the courts, as far as the courts are concerned, life sentence is a rule and death penalty is an exception. And we'll apply that exception as long as the case is made out, if the crime is such a diabolical nature that death penalty is made out. In fact, what we have seen that in the 2611 case, the whole question of mitigating and aggravating circumstances were argued for Abdul Qasar also. And at that point in time, the Supreme Court balanced it and said that it will be right. It will serve the interest of the society if this person was to be given death penalty. So it's not that the courts do not apply or rationally apply their mind while awarding a death penalty. But what the Supreme Court is now saying is that you have to be more rational, more objective in your application of mind.
Okay, more rational, more objective there as well. Now, let me bring in Mr. Suresh Chandra here again. Mr. Chandra, striking that balance with the objective of being rational, but also ensuring that a balance is struck between ensuring that the mitigating circumstances are taken into consideration vis-a-vis the convict, and also taking into consideration the heinous nature of the crime and the impact on the victim's family and the society at large. Mr. Chandra?
Yes. Frankly speaking, if you see this judgment, it will have a persuasive forces over the judges. But practically, if you see the lower judiciary, invariably they are giving maximum punishment maximum punishment is later on being, either decreased or upheld by the High Court. And ultimately, in all the cases, the capital punishment cases, it comes to the Supreme Court. And in all these cases, when we say balancing and mitigating and all, you will see the principles of principles of reasonableness apply. And what are the principles of reasonableness? Are the all those circumstances, all those material, if placed upon before a person of ordinary prudence, the same decision will be taken by him. But we have seen all these having been, principles being there. We have seen most of the time the judges' orientation, background, and sometimes that affects. So I am of the view the balancing was there earlier also. Balancing will remain in future also. But the fact is the responsibility of the judges is there to implement the statute in true spirit, and with that interpretation which has been given by the Supreme Court. And I am again of the view that the balancing will have to be done. The past and the public opinion also has an impact. So I will again say, with concluding, this is something like thesis, antithesis, and synthesis.
Okay.
Like that, the law also moves, and the principles of reasonableness also will improve.
Indeed. Okay.
Move like that.
Okay. Let's take a concluding comment from Sanjay ji here. Sanjay ji, in terms of understanding the context, we have understood as to with what context the Supreme Court has finally come out with these guidelines. But as Ashok was pointing out, that of course, we will have to also take into consideration the way the jurisprudence or the principles of jurisprudence have moved from retributive to reformative as well. And this also is more or less to keep in check the trial courts in a sense that they don't go on handing out death penalties as a rule but as an exception.
Very, very correct. Now, I would like to say one thing here, which is very important, just stuck to my mind, that when, in any criminal case, whether it is a matter of bail at the inception, you look into the antecedents of the person, you look into the family background, as Ashok ji has just said. All those things are very, very relevant in almost all the criminal cases. Now, what was happening up till date, in the rarest of the rare cases, which are where an heinous crime has happened, these points were not looked into. As Suresh ji has very rightly said, that the lower court judges are, they have adopted a kind of prototype and a kind of similar way. They are just printing their judgments. That's what is one thing which must have been there in the mind of the court. So court has very categorically said that these important point of criminal jurisprudence are important here in these heinous offenses also, where you are following, we are aware that you are following the rarest of the rare the principle, and as a matter of fact, it is the death penalty is always an exceptional thing which you should award.
Okay.
One, and of course, please use these, please look into these circumstances also, which are there existing, which most of the time, rather I would say majority of the cases, we miss, and they don't go into these circumstances, and these circumstances are also relevant. With this kind of judgments, I think what you said, that the theory, and we are on the progressive set of, I think, theory we are adopting.
Okay.
That's
So
what I
this
feel.
is seemingly the way forward moving here. Thank you so much, Mr. Sanjay Chadha, Ashok Bagaria, as well as Mr. Suresh Chandra for sharing your views and insight with us and our viewers, as our experts were pointing out and explaining to us not only the judgment, its context, but also what it signifies, and in terms of the overall debate on death penalty, where do we stand? We'll keep a close watch on all the developments on this aspect and many others as well, and keep on bringing you detailed analysis. Till then, keep watching Sansad Television. Thank you.